Aibowan, Vanakkam, Assalamu alaikum, and of course, a very good evening. On behalf of AmCham Sri Lanka, it is my pleasure once more to welcome you to the AmCham Sri Lanka platform of the Legal Review series, where in episode 6 today we'll be discussing insolvency, liquidation, and winding up. Now, as you know, the AmCham Sri Lanka Law Review series is created and curated with the idea or the intention of bringing to you topical issues of relevance in the legal field, especially in consideration of the current socioeconomic climate and what it means to you in terms of your business continuity and prosperity and upward trajectory. So once again, we have with us today an eminent panel of speakers who will provide you with both empirical and academic insights into the topic of insolvency, liquidation, and winding up. Let me welcome our panelists on board. Dr. Harsha Cabral, President's Counsel, for 15 years with 34 years of experience in practice, holds a doctorate in corporate law from the University of Canberra, Australia. He is a sitting member of the International Chamber of Commerce and the International Court of Arbitration in Paris. As a member of the Advisory Commission on Company Law in Sri Lanka, Dr. Cabral was one of the architects of the Companies Act No. 7 of 2007, the current act. He is also a member of the Board of Investment of Sri Lanka, a member of the Law Commission of Sri Lanka, a member of the Intellectual Property Advisory Commission in Sri Lanka, and a member of the Corporate Governance Faculty of the Institute of Chartered Accountants in Sri Lanka. Dr. Cabral is the chairman of the Tokyo Cement Group and the acting chairman of Hatton National Bank PLC. He is also a director of several companies, including listed companies, and he is a lecturer and has authored several books in the field of company law, intellectual property law, and commercial arbitration. Mr. Kushan Dalvis, President's Counsel, took oath as an attorney at law in the year 1985 and has been in active practice for over a period of 35 years. He was conferred silk and took oath as a President's Counsel in November of 2012. The area of specialization of Mr. Dalvis is civil, corporate, commercial, and administrative law in both the original and appellate courts. Further, he has been actively involved in alternate dispute resolution mechanisms such as arbitration, advising on corporate legal matters, regulatory framework, compliance requirements, and legal due diligence. Mr. Dalvis was a member of the Law Commission of Sri Lanka from 2011 to 2015. He was also a member of the panel of legal advisors to the Tax Appeals Commission, and he has served as a member of the Public Representations Committee on Constitutional Reform, appointed by the Cabinet of Ministers. He has also served as the Vice Chairman of the Civil Aviation Authority of Sri Lanka. Mr. Dalvis is currently serving as the Chairman of the Office of the National Unity and Reconciliation, ONUR, of Sri Lanka, and is a member of the Board of Directors of the Lanka Hospitals Corporation PLC and the National Development Bank PLC, which are listed companies in the Colombo Stock Exchange. Mr. Vasant Kumar Niles, Legal Counsel, is an attorney at law holding an LLB from London. He's also an associate of the Chartered Institute of Management Accountants. He's a junior counsel in the chambers of Mr. Romesh De Silva, President's Counsel, and Mr. Niles is a legal practitioner in the commercial and administrative law fields and is involved in litigation and corporate advisory roles. Your moderator this evening, Ms. Gayanthi Gunawardena, attorney at law. Ms. Gunawardena holds an LLB honours from London and LLM from London in banking and finance, taxation, and financial technology, and is an associate of the Chartered Institute for Securities and Investment. She's a legal practitioner in the areas of banking and finance, taxation, project finance, and financial technology, and an academic with demonstrated experience in secondary and tertiary legal education. Good evening, panelists. Welcome to the AmCham Sri Lanka platform. And Gayanthi, over to you to take this discussion forward.
Thank you, Rai. So our topic today, which is insolvency during the pandemic, is very important because the continued travel restrictions and the continued lockdowns have caused severe disruptions in the income flow for businesses, and as a result, most businesses are facing liquidity challenges, and insolvency is on the horizon for most businesses. So they are sort of forced into a dilemma where either they should seek new sources of capital or face the risk of insolvency. So I invite the most esteemed and most learned Dr. Harsha Cabral, President's Counsel, to enlighten us on this very important topic. Sir, from your standpoint, as the chairman of one of the largest banks in Sri Lanka, Hatton National Bank, you would be seeing firsthand the financial difficulties that companies are facing at the moment. So could you please explain the key aspects of the law relating to insolvency, and what key factors should directors and other key management personnel, what are the key factors that they ought to take into account when insolvency is imminent? And what are the corporate rescue mechanisms that are available within the current regime so that they can protect themselves from sliding into insolvency?
Thank you, Gayanti. I believe I must first say that insolvency, liquidation, and winding up, all three come, if you sum it up, it's the death of a company. Right? So what exactly is the death of a company? Like a human being, the company is born with the certificate of incorporation. For a human being, you have the birth certificate. The same way, when a person dies, you get a death certificate. So in a company, the death is after winding up. You get, after insolvency, winding up or liquidation, you have to inform the registrar of companies and your name is struck off from the register. That's the final part of the liquidation. So that is basically the death of the company. Any corporate body, as long as it has funds, it has a purpose to go on, you carry on with your business. The day you cannot go on further, you have to liquidate. The most common thing is lack of funds, like the lack of oxygen. The companies have to fail, and otherwise, if you have proper funds to go on, if there is a purpose to go on, and there is no limitation, there is no time limit. It can be 50 years, 100 years, 150 years, so on and so forth. But the question is, well, when the time comes for a company to close shop or issue the death certificate, if I say so, how does it happen? Why does it happen? And what is the law that is applicable which governs the particular aspect of liquidation of corporations? Well, we have, for corporate law, we have our own company law in Sri Lanka, which is Companies Act number 7 of 2007. Now, the Companies Act number 7 of 2007 is the current act in operation, which has been there for a couple of years now. But while we were doing
I beg your pardon, sir. I think you can't be heard very clearly. If you could increase your volume, sir, it would be a lot clearer, I think. If you could increase your volume.
Yeah. Can you hear now?
Yes, sir. Perfect. Thank you.
So once you reach that stage of the winding up, so you got to see what mechanisms apply and what is the law that is applicable. So when the Companies Act, the current Companies Act 7 of 2007 was drafted, we had our old law, which was Companies Act number 17 of 1982. And prior to that, we had the 1938 Companies Ordinance. And before that, we had the Joint Stock Companies Act of 1861. Now, all these laws, the precursor to the current law, also had the system of winding up. Now, the law that was there to wind up a company, to liquidate a company, or to close shop, to say, was basically available, but it was fairly stereotyped. But when this current Companies Act was drafted, there was a question. It was a moot point whether we should separate insolvency from the Companies Act. In England, you have a separate Insolvency Act. That's not part of the company law, not a part of the Companies Act of England. So we were discussing this, and because we were looking at a separate law altogether, we did not want to change the system that we had. So the old system that was there vis-a-vis winding up continued even in the New Companies Act. Now, in the New Companies Act, you would see it is not much of a change except for the amounts were shifted, the minimum amounts, the rupee and cent amounts were shifted. But overall, what was there in the winding up regime under the old Act, Act number 17 of 1982, continued per se. Now, so the law that is there in our act, the current Act number 7 of 2007, is seen in part 12 of the Companies Act. It's with the heading winding up, right? And for that, we still follow the 1939 winding up rules. I must admit that they are absolutely archaic, right? The corporate law that was existent in 1930s is not the same that is there in 2021. But unfortunately, the winding up rules are still the same what we had introduced in 1939, the same rules which applied for during the 17 of 1982 Companies Act regime. And from 2007 onwards, we have been using that. Now, that is a fairly stereotype mechanism to wind up a company. There are very, very standard things. And if you look at the current Companies Act, there have a couple of questions raised also. The sections speak for itself. The current Companies Act has 534 sections, 13 schedules, and 46 forms. Now, out of these 534 sections, winding up is dealt with in sections 266 to 399. The entire law of winding up in this country is seen in part 12 and sections 266 to 399. You find it under three categories. Winding up by court, that is basically the creditors winding up, right? The second category, the voluntary winding up, that is the members winding up or creditors winding up. And thirdly, the winding up subject to the supervision of court. Now, in all these situations, the company, the most commonest thing is the first category, where the inability to pay debts. Now, there again, there is a small problem with the singular and the English. In the English translation, it has gone correctly to say inability to pay a debt of 50,000 rupees. But unfortunately, in the singular one, it says Pandazak, which means 5,000 rupees. But by practice, from the date it came into operation, the commercial courts, we have accepted that the courts have accepted that it is 50,000 or more. Now, where a person is unable to recover a debt above 50,000, and a statutory demand is made by the hand of that person or the company to the company to be wound up. And if that company is unable to pay that debt, that's a solid ground. In addition, there are several other grounds to wind up, but this is the most commonest ground where you go to court to wind up a company. That is to say, the company is unable to pay its debt. Now, the procedure to go into this is seen in the winding up rules. It's not there in the Companies Act. 7 of 2007 doesn't have it. 17 of 1982 didn't have it. 1938 ordinance didn't have it. So it's the winding up rules prevail when it comes to rules are very, very, as I told you, rules are totally archaic, right? And that is something we have to look at very seriously. And the procedure is laid down how you have to proceed to wind up a company. Now, the first thing that happens when you go to wind up a company, you go to court, you present the winding up petition, and the court has to look into that matter and give a date for inquiry, give a date for publication of the notice and the gazette, and give another date to see whether those have been complied with before the inquiry date. Now, then all the procedure laid down in the winding up rules of 1939 takes over. When to file the affidavit, when to file the verifying affidavit. There was a question asked, It's the same. Verifying affidavit is just one that is supporting what is there in your pleadings. There is no two meanings to verifying affidavit, right? So the time frame, how what has to be done by the instructing law, the lawyer who is filing the petition, who can oppose the winding up, who can support the winding up, what is their role, how should they put into this thing, where the time frame, procedures, affidavits to be filed, all that happens. Now the public get this now. That is a private operation when you do it to court. The public gets to know about this winding up application when it appears in the newspapers. You have to publish it in three single English and Tamil newspapers and the Gazette. Now those ones that happens, only the public gets notice. Then they know that, okay, this company has to pay me so much. I must also walk into court. So the procedure, all that is set out in 1939 rules. Now the first thing when you support, what happens is the court, and you ask for it, and the court appoints a provisional liquidator. Later on, that person becomes a liquidator. Now, actually, the liquidator's job is basically an undertaker's job. You see, you know what A. Freeman's or Jairatna's would do. It is the same thing that the liquidator will have to do. He will have to look into this. It takes over lock, stock of barrel, the whole operation. Now, there was some couple of questions that were raised. What happens? Can you carry on with the company? Can you have board meetings? Can you can the directors appear in court? Can cases be settled? Can payments be made to creditors? No. Once the petition is filed in court and the court accepts the petition, from that point, because that is why you appoint a provisional liquidator who becomes a liquidator. Liquidator has to do everything. You can't have board meetings, you can't issue shares, you can't have an EGM, you can't have an AGM, you can't settle creditors, you can't appear in court. All that, the correct way is to do. If you have to make EPF payments, all that, all the statutory payments, you might, there are some labor issues, labor laws that come in impact on this. The liquidator is the correct person who has the authority to act for and on behalf of the company after the presentation of the winding up petition. Now, this is a question. These a lot of questions have been raised on those areas. That's very clear. You cannot. Even if the liquidator can get permission from court to sue anyone else, and if there are other cases to proceed, even they, once this happens, they have to get permission from that winding up court. Now, the winding up court in Sri Lanka, if you go to wind up a company under the Companies Act, you have to go to the Commercial High Court. Under 7 of 2007, for under the section 529 definition sections, it is very clearly said that the assigned court, if you come to any provision of the Companies Act, you have to go to the Commercial High Court. That is the Commercial High Court sitting in the Western Province. You have 3 different courts now. So you can't go to any other court. You can't go to a district court to wind up a company. You can't go to a magistrate court to wind up a company. So it is the Commercial High Court that can wind up a company, that can appoint a provisional liquidator, that can appoint a liquidator, that can look at all the creditors, supporting creditors, opposing creditors, observations, and all that is vested in the Commercial High Court. So now the liquidator's job is to look at, take over lock, stock and barrel, look into the transactions of this organization and see what the assets are and what the liabilities are. There are several reports he has to submit to court. Now, while doing that, he has to list out what are the assets, what are the liabilities. So what happens is, he has to, then there are several reports he has to submit to court, and then he goes to court finally and say, this is my final report. This is how the payments are made. This is how what I've collected. Very often, it's very common that the assets are not sufficient to meet the liabilities. So the principle in the limited liability process is that if your assets are not sufficient to meet the liabilities, you got to, the shareholders have to chip in. It never happens because winding up cases go on and on. By the time the winding up case is over, you can't even find the shareholders and the shareholders liability, and then you find that the shareholders or the members don't have sufficient money for themselves to, so you ultimately get played out. Now in the process, the liquidator has to, when he's making payments, the payment part of his, the preferential claims he has to look at, that is in the 9th schedule of the Companies Act. That is, first of all, the cream is taken over by the statutory payments, right? All the statutory payments have to be sorted out first. Then comes the secured creditors, and thirdly, the unsecured creditors. So by the time the first two is gone, very, very rarely you get an opportunity for the unsecured creditors to get any. So the other risk-bearing creditors, they get ultimately played out. So this is the structure you have in winding up. But unfortunately, this situation does not deal with restructuring of companies. You know, now the present day and age, you don't let a person die straight away. You will try to do a bypass, you will try to do put a stent or do whatever possible to keep the man going. Now that mechanism is not available positively in our Companies Act. That is a lacuna. The only available routes are seen in part 13. We created under the new Companies Act, which was not there earlier, the administrator. In a situation when the company is ailing, and if the company still feels that you can do some recovery to a certain extent, you can appoint an administrator. Sections 400 to 426 deals with administrators, how an administrator can try to restructure, turn around, or say get going a company that is ailing. There is a procedure laid down, very clear procedure. Go with that scheme, tell court this is how we are doing it, and then you keep the board of directors aside and the administrator. There are a few cases under the 2007 Act which has succeeded, but it's not very common. Right. Then under part 8, we have amalgamations. That's another way for companies that are not doing that too well to find. You know, long years ago, the central bank promoted for finance companies when they started collapsing, why don't you all merge? It was compulsory to merge with a A-class finance company with a C-class finance company, right? So merging, though you don't let both companies collapse, but you try to merge the two companies and go forward. Then part 9 of the Companies Act has compromises with creditors. That's another mechanism. When there are too many creditors, how best, but the creditors must agree, the mechanism is set out. Then part 10 deals with approvals of arrangements and amalgamations and compromises by court. There again, you can go to court and say, okay, these are the only mechanisms that are available under the Companies Act. But per se, there is no proper mechanism like what you see in the US. US, you have Chapter 11. That is absolute total business recovery. Then you have in Malaysia, the Danaharta model. Right. Then in India, you have the Sikh Industries Companies Act, where they try to resurrect dead companies. Now, when the going is bad, you know, there will be so many companies which will not be solvent, which will go into insolvency situations, serious loss of capital situations, you know, 219, 220 of the Companies Act, where the solvency levels are not possible to be maintained. Company boards have to take a call whether to close shop or whether to go on with certain other mechanisms. So unfortunately, we don't have that mechanism. We looked at it, a draft law was made, but it stuck somewhere in the pipeline. It didn't match. So the idea was to bring in those, to get some information from those areas and to see whether you could restructure company, you see, whether you can downsize, whether you can, you know, sell some of these assets and keep it going, settle some creditors and enter into mechanisms. So that is what company restructuring is all about. I mean, in other countries, there are insolvency experts They are the ones who get involved in this. But unfortunately, it doesn't happen in Sri Lanka. So there is a lacuna with regard to that. But if you talk about the existing systems, that is where I told you part 12 of the winding up thing, then part 13 of the administrators, then part 8 of amalgamations, part 9 of compromises with creditors, then part 10 with arrangements, amalgamations, compromises by court. Those are the existing rules. So you've got to work within. But unfortunately, the system is sometimes with the Pareto execution law we have for the banks, sometimes if you're restructuring, well, the moratoriums come in, so on and so forth. So sometimes it's better for the bank to, come in and use the Pareto execution mechanism, recover whatever. But in the present case scenario, I would like to discuss after the other speakers also discuss the different options to see how best we can go forward in a situation. Now, we have never experienced what we have gone through in 2020, 2021. So the companies, I know not only the leisure sector, there are so many other sectors that are feeling the pinch. So how do they go forward? What have the other countries done? Say, providing a moratorium from a bank, will that be sufficient? How long are we going to provide the moratorium? So non-performing accounts in banks are sky high now. If you talk to all the banks, all the top banks or small banks or big banks, it's the same story. So we will have to see how as we go forward. I know the central bank is coming forward to help people, and the governments are trying to come up with mechanisms. How best we can solve is a matter we have to discuss. But what I just mentioned was the existing legal system and, well, the downside of it also. Thank you.
Thank you very much, sir. Thank you very much, sir. So I now invite the most learned President's Counsel, Mr. Kushan Alves, to give us some insights about the practical aspect of our topic today, which is insolvency during the pandemic. Sir, in your vast experience of having represented and advised several banking institutions, you may have seen over the last year an increase or a change in litigation. What is your opinion on that? Has there been a change in has there been an increase in litigation of companies being liquidated? And what would be your best advice to companies that are contemplating or involved in liquidation proceedings, if it has come to that? Apart from, of course, the well-known remedy of coronavirus bank moratoriums, what are the alternatives with regard to their financing arrangements with banks? I beg your pardon, sir.
Right, fine. First of all, I must thank the American Chamber of Commerce for organizing this seminar and webinar and inviting me. In respect of the first part of your question as to the onset of, because of the onset of the pandemic, whether there has been an increase or change in litigation, I must say that there has not been any increase in litigation vis-a-vis recovery, because the moratoriums are in place at the moment, and also the directions given by the central bank and also the government has resulted in the banks not pursuing the legal remedies in respect of defaults. And at the moment, I believe it's the moratoriums are on till the moratorium is on till end of August this year. But however, I feel that even if the moratoriums are lifted, the banks should not rush in to filing action or pursuing Pareto execution, because I feel that there has to be basically a duty on the bank as well to support the customers in distress. That is, they must sustain genuine, loyal customers. So in this regard, the fact that the one has to take into consideration their track record with the bank, and also the fact that the effect of the pandemic has taken on the financial and the cash flow of those companies. Those have to be taken into consideration. And I feel that there is a responsibility on the banks as well to ensure the customers are not taken to court, or parate is not executed against their properties unless it's a last resort. And as regards to the question of the best advice to the companies which are contemplating or involved in liquidation proceedings, I would take the first part of it, who are contemplating liquidation proceedings. Because if it's already involved in liquidation proceedings, of course, the matter will proceed unless there is no, unless they find some kind of a way out. But on the other side of it, if they're contemplating, I would first suggest that, there are the remedies are twofold. One is first to see whether it's possible to follow some financial remedies, like asset liquidation, fresh infusion of equity by the shareholders or the investor, drawing on retained profit, or restructuring the business, so on and so forth. Failing that, of course, you get the legal remedies. That is where, like Dr. Cabral, President's Counsel, said, you get, as set out in Part 8, the provision in the Companies Act for amalgamation. Then Part 9, compromise with creditors. Then Part 10, approval with the approval of court arrangements, amalgamations and compromises. In fact, there is one matter that I'm personally aware there is one matter at the moment on this under Chapter 10 pending in the Commercial High Court. Then, of course, the appointment of administrator. Then, of course, finally, the inevitable, that is the winding up, which is under 3 categories: by court, voluntary, and subject to the supervision of court. Now, with regard to this, the question of the bank enforcing the security or instituting action, I must say that, if it's not, the best chance for the bank is to help the companies which are in distress to come out of it. And I feel now at the present moment, banking is not the banking which was there years ago. The banker-customer relationship now goes beyond a pure banking relationship where, you apply for a loan and they assess your assets and then they give you the loan. Now, I know so many banks which basically help out the customer. That is, advice by way of advice regarding restructuring and offering refinance, then to help them to look at the business model, what they have, identify the problems. Then also, especially with regard to small and medium scale enterprises, encourage them to work digitally or online, because some of them have not progressed. Then also sometimes the banks help by matching customers, because if one is producing something and there's another person who's exporting it, try to match customers, put them in contact with each other. Then also to introduce companies which will maintain a software system for their accounting, proper accounting. Then also help customers to attend workshops by like the Asian Development Bank and various other chambers, which will help them. So these are the role I see of the banker, to try and first help the customer who's in distress. And these are, I would say, goes a little beyond the realm of the normal bank-customer relationship. Because I feel that one mustn't take the umbrella away when it's raining. It is only in dire cases where the bank feels that there is no alternative, but they have to resort to legal action or parate, that they should do so. Now, in those circumstances, when one considers, there are instances even before these moratoriums were brought about, earlier situations where customers, genuine customers who have had a proven track record, have fallen into difficulty. Banks have come forward and imposed a self-imposed moratorium. So I feel that is the way forward to help out this problem which is faced by the industry. Certainly, I do concede, as the banking industry also has its obligations, because you get the depositors the money, they have to basically safeguard those interests. That is true. But then also on the other side of it, I feel that it's, like I stressed earlier, that it must go beyond now the banker-customer relationship, and the banks should be more proactive in trying to help the customer who is in difficulty to come out of. Then also, it will be in the interest of the bank, because now, for instance, you go ahead with parate, once we'll say the moratorium is lifted, you go ahead. Majority of these companies have basically wouldn't have anything much by way of assets. Then you get into their immovable assets. You go by way of parate with the present market conditions, it will be difficult to resell. So ultimately, the bank will end up purchasing these properties, and there hardly any useful purpose will be served. So in those circumstances, I feel that the banking sector's response towards these non-performing loans should be a very, I would say, kind of a supportive response to the customers in distress, and help them out as much as possible. So I hope that would basically cover your question.
Thank you very much, sir. So now I invite Mr. Nayas, who is a junior counsel in the chambers of Mr. Ramesh De Silva, President's Counsel, to explain to us what the alternative options, apart from winding up, what are the alternative options, and what are the ways in which the law as it stands today, what are the ways in which the law supports the survival of a business?
Thank you, Gayanti. And I take this opportunity to thank the American Chamber of Commerce for this opportunity. So, as you very clearly mentioned, the survival of business is the other important factor. It's the other side of the coin when the question arises. This has been very clearly explained by the two learned President's Counsel. Now, Mr. Dialvis stated very clearly that winding up is actually a last resort. The focus should be on survival. It's very useful for us in Sri Lanka to think afresh, to consider a rescue culture for companies in financial difficulty and emphasize on survival. Now, Dr. Cabral very correctly stated that there is no Chapter 11 bankruptcy law in Sri Lanka and no scheme for restructuring. But as he very correctly said, the law has some existing options. The Companies Law, the Companies Act, as it was creatively drafted, has some practical routes for survival. And these routes, very importantly, give companies breathing space. So I will expand a little bit and look at the practical way of approaching it as to the areas which were covered on focusing on survival of companies. Now, I must preface this by saying that these options require the close cooperation of a company with its creditors. A company can't go solo and attempt to choose these options without being with its creditors and cooperating with its creditors. I can't stress the importance of this because without the cooperation and participation of the creditors, many measures would fail. Many creditors, like banks, as Mr. Dialvi said, may prefer to get their monies by way of parate executions, even if at the end they receive much less than the loan that they gave. And that leads to a lesser chance of the company surviving. So now I will just go on to very briefly, extremely briefly, talk about the existing options. The first option, as discussed by Dr. Cabral, is takeovers and mergers, which is present in our law. So as we all know, it would involve the acquiring of a company or the merging of a company. In fact, a company facing a crisis might make an attractive takeover option if it has resources such as intellectual capital, trained staff, and those in the corporate sector would have a better understanding than me of the financial and other practical implications of takeovers, such as reduction of overheads, you avoid duplication of processes, you acquire resources and expertise. So the law of takeovers and mergers is covered under the Takeover Code, and as well as the Companies Act, which provides for amalgamations. Now, the Takeover Code, I must just very briefly say that it focuses on fair and equal treatment to shareholders. So if you're planning to take over a company, all shareholders must be treated equally. Then there should be also equality of information to all shareholders. Now, the Companies Act, as discussed by the eminent President's Council, provides for amalgamations. Two companies, now practically, how does this happen? Two companies can amalgamate to continue as one company. The amalgamated company can either be a continuation of one of the companies which was amalgamating, or a brand new entity. And the interesting thing is, amalgamations do not require the involvement of courts. Is one less hurdle. A few things to keep in mind. The amalgamation must be approved by the board. The board must see it in the company's best interests and that the company will satisfy the solvency test. That is, that the company should be able to pay its debts as they become due in the normal course of business, and the value of the company's assets should be greater than the sum of its liability and stated capital. And as I said before, cooperation of stakeholders is essential. Amalgamations must be approved by the shareholders, and the creditors too should be notified. However, board approval is sufficient for short form amalgamations. That is, amalgamations involving a company amalgamating, for instance, with its fully owned subsidiary. Now, there are other remedies as discussed for survival of companies in financial distress. These are, as the learned President's Council very correctly said, arrangements, compromises, and administration. Of this option, the most informal of this are arrangements. Now, what are arrangements? In this option, a company in difficulty can enter into an agreement where the company in difficulty negotiates with its creditors and other stakeholders to restructure its balance sheet. It can do this, for instance, by converting debt to equity. So this this entering into negotiation is something which Mr. Dialvis very correctly said is very important. And further, to give this agreement even more teeth, a company or creditor, you can even go to court under the Companies Act and obtain a court order and make this arrangement binding. Another option for survival, as Dr. Cabral said, is compromises. Now, the whole point of a compromise is that it assumes that there is a dispute between a company and creditor regarding a debt. So, the Companies Act very creatively enables companies to enter into a binding agreement with creditors without the need to get court involvement. So the Act specifies a compromise would involve a reduction or a cancelling of the company's debt, or even a variation of the company's debt. So there should be a give and take between the company and its creditors. The giving and taking might include, on the part of the creditor, an agreement to restructure the debt, maybe to give some relief, a time relief for payment, or even a reduction or waiving of interest. However, the company also must take a hit. It must play its part in the compromise. So a company may have to agree to obtain new funding through equity. It might have to take painful decisions, as Mr. Dialvis said, of selling and disposing assets to raise funds. And even it might even have to give fresh security to the creditors. So in short, the aim of a compromise is that it should be reasonable and beneficial to all parties. One party should not be getting all the benefit. So very briefly, I don't want to waste too much time on this, but compromises are less procedural. So even the board can propose it, or a shareholder creditor. And the Act provides that compromises suggested by the board do not have to go through court. However, as I've always said, cooperation of creditors is vital. Compromises under the Companies Act require approval of the creditors. And when it is approved by the creditors, it binds the company. To get further teeth, a binding order can be even obtained from court. The final option, as the Learned Persons Council said, is administration. It's a very, very powerful process where a person called an administrator is appointed to take over control of a company. And this happens when a company is already in financial difficulty. And it's something brought in under the 2007 Act. So the aim of administration is that when the board finds unable to pay, the company is unable to pay a debt, the board can appoint an administrator with the aim of survival of the company, or preparing a compromise with creditors, or even to get a better deal of disposing the company's assets and winding up. So you can very clearly see that the draftsmen of the Act have very clearly conceptualized the survival of a company. And the administrator has huge power. He can manage business, property, and also very importantly, a company gets some protection. A moratorium is imposed. So no resolution can be passed by anybody to wind up the company, except through court. No one can enforce a security, except through court or with the administrator's consent. So the moratorium given by administration is attractive, as it gives the company a little bit of breathing space. And the Act contemplates, as I said before, that the administrator can take steps to see if the company can survive. And the Act very correctly provides a very strict time limit. So, for example, the administrator has to present his proposal to the creditors within 2 months of being appointed. However, as I've always said before, the success throughout of an administrator too requires the administrator receiving approval of the creditors. His appointment should be confirmed by the creditors. So, in summary, as the Learned Persons Council have stated, the other side of the coin to insolvency and liquidation is seeing if there is a possibility of business survival. And the law in Sri Lanka, it doesn't provide, as correctly said, for a complicated, a thorough restructuring. But there are, in fact, a few options which companies should make use of. Takeovers and mergers are discovered, as discussed before, are a useful option for a company difficult looking for resources. Other options, as I said before, and as Dr. Cabral and Mr. Dialvi said, are arrangements which involves restructuring of a company's debts, compromises involving agreements of a give and take nature with creditors, and administration, which involves appointment of an administrator to manage the company and see if it can survive. So I reiterate that I cannot stress how important it is for companies to work very closely and obtain the cooperation of creditors to ensure success of these remedies. This involves an absolute change of mindset. It involves an attitude of survival and rescue. And who knows, implementation of these measures may perhaps help a company avoid the road of winding up. Thank you.
Thank you, Mr. Nayas. We can move on to our question and answer segment. One of the questions is, what is the difference between an arrangement and a compromise? As both are in agreement with the creditors, what is the section in the Act relating to this? Dr. Cabral, sir, if you can answer this question.
10 deals with that aspect. Part 10 has both. Deals with arrangement, approvals, compromises by court. Right.
Okay,
So it's
thank you.
Yeah. And compromises are always with creditors. As long as as the other speakers mentioned, the creditors' blessings are important. You know, the idea is not to play out in simple company law. What says is you cannot, you can make profits, you can make losses, but you can't cheat the creditors and your stakeholders, shareholders. So because the creditors have the right to wind up the company. So you've got to come to some arrangement. Now say, if you're in debt right now, you know you don't have income to pay, but if you go and discuss with that person and say, look here, no sooner I get my salary, I will pay. I mean, now if you look at the current situation, not the corporate, but a lot of people are unable to pay their house rent, right? Say not the salaried people, but the day-to-day earners and things like that who are running their own businesses. So a lot of organizations, I mean, a lot of landlords have given them time to settle. At least to say, okay, we'll give you 2 months free, or then thereafter you pay, or at least start paying from when you start, because that is better to, otherwise you might lose your tenant also.
Thank you, sir. There's another question. In the event of winding up of a finance company registered in terms of the Finance Business Act, is the procedure the same as stipulated in the Companies Act? Mr. Kushandiavis, sir, if you can answer that question.
Yeah, I'll take that. Any company, it's the same. Winding up, if it's a company registered under the Companies Act, you have to fall under the procedure that is laid down in the Companies Act. But only issue is if it's a registered finance company, you come under the purview of the central bank. You have the central bank, bank supervision and non-bank supervision. Non-bank supervision is for finance companies, leasing companies, hire purchase, and so on and so forth. So you've got to satisfy a couple of directives there, but overall, it's the winding up of that particular company under the Companies Act.
Thank you.
Sorry, Harsha, my mic was on mute. That's why I couldn't. This thing, yeah, it's what Dr. Cabral says is correct. It's basically it goes as a normal winding up, except of course there are certain regulations and guidelines which come into play by the Central Monetary Board of the central bank. But basically the provisions of the Companies Act have to be followed in respect of that as well.
Thank you, sir. The next question is, if there are no funds left over to service the unsecured creditors, can they find the directors personally liable and file action against them?
Except in certain sections, there are few sections in the Companies Act where you can go against the directors. That is for fraudulent trading and so on and so forth. But not it's not a blanket thing that just because the whole principle of limited liability is the shareholders have to chip in. Now you say, if you and I start a company, 50, you have owned 50% and I own 50%. And after the winding up, the liability is 10 million, you see, and say the assets are say 5 million and the liabilities are 15 million. So there is a net 10 million going to the unsecured creditors. So now for the unsecured creditors, the correct way is unlimited liabilities. My limited liability, you and I will share 5 million each. But unfortunately, it doesn't work that way, because if I come and say I don't have 5 million to pay, you come and say you don't have 5 million to say, what do only in exceptional circumstances they can go against the directors. One example is in 374, fraudulent trading.
So thank you very much, sir. The next question is, Mr. Kushan Diavis, sir, if you can answer this. Will there be an impact for the banks and financial institutions from the proposed COVID-19 bill, which provides some remedies for various borrowers?
There will be an impact, but of course, on the other hand, the question of now we say, for instance, the period of limitation or prescription has been kind of extended. So therefore, certainly I would say that there will be an impact, but I wouldn't call it exactly an adverse impact, but maybe it will delay the recovery process. But I, for one, who feels that the bankers should be more proactive and, basically try to help out the distressed customer and try to come to a win-win situation. Maybe it has to be, both sides have to, cut some of their losses. So in those circumstances, I feel that the act is in a way helpful to that end. But of course, as vis-a-vis the, how shall I say, if I may use the word, the fraudsters, or I would say a kind of the companies where some of the directors and they just without servicing the bank loans, they have skimmed off the profit and bought apartments and made their own personal share portfolio of that without servicing the bank loans, and have a bad track record. They too will, of course, benefit from this.
Thank you, sir. The next question is an administrator and liquidator the same?
So they are two different people. Liquidator is, I told you, they like the funeral director, see the funeral. Administrator is not there to see the funeral. Administrator is to see whether he can do something to get going. Two different roles played.
Thank you, sir. The next question is, can a company appoint an administrator to prevent a priority proceedings against its security?
So generally, when an administrator is appointed, there is a moratorium of some sort, but a person can always still take action with the sanction of court, or if they get the consent of the administrator. So those options are not completely eliminated.
Thank you. The next question is, can a company recover from insolvency due to this prevailing situation, and what are the steps?
Come again?
Can a company recover from insolvency due to this prevailing situation, and what are the steps?
Recover. No, recovery
Yes.
is this companies which are in distress. we'll have to take a call and see how do we go forward. Are we going to, I mean, if it's so impossible, then they will have to take a call. That is why, under the Companies Act, there are two important sections, 219 and 220. 219 is a situation where there is the company is in a insolvent situation, and 220 is serious loss, companies in serious loss of capital. In these two situations, the board has to take a call. So a very serious call, because the shareholders won't know the actual financial position of the company. They get to know only when the quarterly reports or half yearly reports or the annual report comes out. So it's a responsibility of the board. So the board has to immediately inform the shareholders and say, look here, going is bad, what do we do? If the shareholders say, no, don't worry, this is a temporary thing, COVID will vanish in another 2-3 months' time, don't worry about that, we give you the blessings to go on. If they do that, that's fine. If they don't inform the shareholders of the current position of the company and carry on happily, they will be held personally liable, not only civil, criminal liability also. So that is a call they have to take very seriously. And that doesn't mean that you just close shop and go. There are so many things for survival. You can downsize, you can sell off certain unusable assets, you can reduce the number of employees, and there are so many things you could do. I mean, individually you will do it, corporations you would do it. So that is what is left for a prudent board would do it, and then they will decide, okay, that is what they are supposed to do, and then this is how to survive in different, during the 30-year war, companies survived. During the COVID 2019, after the bomb blast, they survived. So 220, 221. So there will be the strong company. They are just saying that when the going is tough, the tough gets going.
Thank you, sir. The next question is about Section 275 of the Companies Act says that you cannot dispose properties. In terms of that, can the company make essential payments like salaries, rents, EPF, and ETF?
All those are that is where once the company goes to liquidation is made, the liquidator is appointed. It is the hands of the liquidator. Directors have no role to play. So it's the liquidator can make whatever payment for the rent from the building or whatever payments. It's up to the liquidator. Otherwise, you have to get permission from court for any of these actions.
Thank you, sir. The next question is regarding mortgages. So, Mr. Kushan Dialvis, sir, this next question is to you. When a company has a primary mortgage bond with Bank A and there is a secondary mortgage bond with Bank B over the same property of the company, and when the company files a winding up application in courts as they are unable to pay its debts, can Bank A and can Bank B execute parate? And if Bank A obtains certificate of sale, how does Bank B recover from the company?
It will basically go as a primary mortgage and a secondary mortgage, and the parate rights are unaffected by the fact of winding up, because they are basically secured creditors. As well as on the other hand is that if there is any remainder of the proceeds of the sale by the primary mortgage, then the balance will be payable to the on the secondary mortgage.
Thank you, sir. The next question is.
Sorry,
that's something, because as Kushan says, parate execution is a very strong weapon in the hands of the lending institutions. So that has been, Act numbers 1, 2, 3 of 1990 brought in very, very strong this thing. So we have actually, if you look at most of the banks in Sri Lanka, now they are basically in real estate. They have recovered so much of property, and they may have, some banks may have more property than real estate agents. So whether it's in the hands of the lender, the bank, they have a very superior right with regard to parate execution. They can decide whether they want to execute that right or to go and stand in line in a winding up.
Thank you, sir.
There was
The
another
next question is, yes, sir.
That just came up. I saw on the screen.
Yes.
Company is dormant. What can you wind up the company?
Yes.
Very under Section 270 of the Companies Act. There are several grounds in addition to just an equity. Those are grounds to wind up the company.
Thank you, sir. The next question is, in the event of winding up of a finance company, should the decision to wind up be taken by the monetary board, or can it fall within one of the modes of winding up as stipulated in the Companies Act?
You can follow the winding up mechanisms in the Companies Act, and in certain cases, the non-bank supervision and the monetary board has stepped in situations where there has been more than winding up. There have been fraud and certain other instances. So they have power under the Central Bank, the Banking Act. They have powers under the non-bank supervision. They have powers, but any creditor can go to wind up the company under the winding up rule.
Thank you, sir. Mr. Dialvis, sir, the next question: exporter debtors who are not paying, can they use the Sri Lankan Companies Act provisions or foreign countries Companies Act? If the exporter customer doesn't pay, what provisions are there for the Sri Lankan company to recover money?
Question is not very clear.
Yes.
Basically, what you're saying is if the foreign buyer doesn't pay, I guess.
Yes, I think so. Yes, sir.
So
if the exporter debtor who's not paying,
exporter
debtor, whether
buyer,
they can.
I think if the buyer doesn't pay, I mean, you export goods and the transaction.
Yes, but I think the question is asking about the applicable regime, whether it's the foreign regime or the local regime that's applicable. I think that's the essence of the question.
It's basically, your import trade is on contract. Whether it's a letter of credit transaction, there are other mechanisms. You can't, without paying, you can sue on the contract, whether it's a LC transaction or any other payment mechanism. You have a contract. So if you're going to sue that person on that contract will prevail.
Thank you, sir.
To sue and under what law to sue?
Yeah, and also it depends now. If you have to sue a foreign party, then the question of jurisdiction also arises. If you have to sue a foreign party, otherwise, of course, it will depend on the terms of the letter of credit or the relevant contract between the parties.
Thank you, sir. The next question is, in a serious loss of capital, can the company propose voluntary winding up?
Yes, provided they
Mr.
can.
Niles? Yes, sorry.
That is under Section.
Sorry, sir. Yes.
Serious loss of capital. They can come up with a formula, settle the creditors, they can go for voluntary winding up.
Thank you, sir. The next question is, how can a secured creditor recover money in terms of Section 358 of the Companies Act?
Secured creditor will have to fall in line with the normal under the preferential scheme. So, secured creditor, either he can, as Kushan said, write on the security go on parade, or go under in the winding up route and stand in line. Secured creditor comes over the unsecured creditors, so he gets a definite superior claim on that.
Thank you, sir. The next question is, can a party intervene in a winding up action before publication of notice?
Yes.
Yes.
So there's a series of questions. It's about, may I read it out? So it's a little long. If a bank is a trustee of a loan arrangement where there is a clause that the trustee can execute the property kept as mortgage in the event of non-payment, can the bank as a trustee enforce repayment if the borrower undergoes liquidation prior to the liquidation order? Mr. Dialvisi, if you can answer this.
I'm sorry, you bro. I think your question.
I'll repeat. I'm sorry, sir. I'll repeat the question. If a bank is a trustee of a loan arrangement where there is a clause that the trustee can execute the property kept as mortgage in the event of non-payment, can the bank as a trustee enforce repayment if the borrower undergoes liquidation prior to the liquidation order?
If it's if you are referring to a ATM or agreement to mortgage, because the Companies Act doesn't recognize trust as such, but basically if you are referring to agreement to mortgage, where the bank, the CEO or the chief executive officer has been given the power to execute a mortgage in the event the borrowers do not, or the obligor and the mortgagor fails to execute a mortgage, then the bank can execute that mortgage and then proceed with as a normal parate, if it falls within the parate. What do you call the financial limits and the parameters of parate, the mortgage bond, then the bank can, the CEO of the bank can execute the mortgage and then thereafter enforce it. Because like I said earlier, as regards to the secured creditors, when it comes to parate, the winding up process is not a must.
Thank you, sir. The next question is, as per Rule 9 of the Winding Up Rules 1939, petitions shall be verified by an affidavit verifying thereto, and such affidavit shall be filed within 4 days after the petition is presented. As per
I dealt with that in my presentation.
Yes.
Verifying affidavit is one. I saw that question. There are no two different meanings to verify an affidavit. Verifying affidavit is the supporting affidavit, what is there in the petition or any other pleading. So there are no two different meanings to that. You're giving sworn testimony to say what you have said in the other document is the same. You're swearing. That's a sworn testimony of the pleading.
Harsha, there is one issue regarding this about the affidavit in opposition, that the time frames don't seem to be practical in the present. It's because 7 days. It's like you said, it's an archaic rule, and the 7 days regard to the affidavit in opposition is not practical at all.
Fully agree.
The next question is, sir, can credit card owners that don't settle their outstanding dues, what can a bank do where a credit card owner doesn't settle his outstanding dues? Basically, that's what the question is trying to say, I think.
A credit card, though it's a credit card or whatever arrangement, is a contract. You can if they don't pay, you have to sue on the contract.
Thank you, sir. There's one more set of questions. It's regarding the Inland Revenue Act 2017. So the question is, what is the position of paragraph 7A of the 9th schedule of the Companies Act? How is it changed by the new Inland Revenue Act 2017 in the event of insufficient assets? And should the Companies Act be amended in this regard? That's one question regarding.
From the statutory section, Schedule 9 deals with the preferential payments, right? So it's Inland Revenue payment.
Yes.
So the statutory payments front, you have to pay them.
All right, so thank you. Then what are the current developments in this area of corporate insolvency law in other countries? ranking of Crown and other preferential claims. This is still with regard to the tax dues in the event of insolvency, unpaid tax dues, and how preferential claims are dealt with regard to that. So,
the statutory payments are upfront.
yes.
Any other questions?
I think that's all, sir. That would be all, sir. Thank you very much.
Thank you.
Okay. Thank you. Thank you,
Thank you.
Kushan. Thank you.
Thank you. Thanks,
you.
Harsha. Thanks, Vasanta. And thanks,
Basanta.
Gayanti.
Thank you, Gayanti.
So
Thank
that
you very
brings us, I think, to the end of this very important session. I believe we had many more questions that came on email as well as via Facebook and YouTube. So what we will do, because we're well over time now, is share those questions with you by email. Our panelists have very kindly agreed to consider and respond to them. So we will share the responses with you via email. I think Gayanti did her absolute best to run through them, but there were some that were extremely long and had multiple questions within one. So I think we'll take a little time and get those across to you. As I said, that brings us to the end of the 6th episode of this all-important series that provides you with insights and information related, of course, to topical legal issues that impact your business continuity. Thank you to our eminent panel of speakers, and of course to all of you here on Zoom, on Facebook, and on YouTube watching us. The AmCham Sri Lanka Law Review series is supported by LMD and the Ceylon Today. And as always, a reminder to subscribe, share, and of course, click the alert button on our YouTube channel, which is what will assist us to continue bringing AmCham's diverse and impactful online resources to you free of charge. As we conclude, a reminder from our panelists, the AmCham team and myself, let's keep our physical distance, masks on, hand sanitized, immunity boosted, fingers crossed, and spirits up. Stay safe, Aibowan, and God bless.